And do we have Mr. Biasotti?
There.
There we go.
Oops. Okay.
There you are. All right, Mr. Biasotti, you are the appellant today. Would you care to reserve up to 5 minutes time?
Yes, please. 5 minutes is great.
You got it. Go ahead, sir.
And good morning, Your Honors. My name is Robert Biasotti, and I represent Mr. Stacy Signorini in this appeal challenging an order denying attorney's fees in a mortgage foreclosure case. In this case, the trial court originally granted his motion for fees, record 639 to 40. And then the court, on a sua sponte decision to review her order based on this court's Hobson decision, which the court determined was, quote, no standing, no fees. That's in the record at 755. We assert that interpretation was incorrect, but it may be a non-event because the Supreme Court issued the Page case, Page versus Deutsche Bank, which approved the Harris decision. And it held that the universal fee provision in the contracts with an S are at issue and made reciprocal. And then we just filed this week the Blythe versus Ocwen case, decided last week by the 4th District, that said even if the appellee has not been assigned the note, the appellants would still be entitled to fees under 57-1057 because of the fee provision in the mortgage, citing Harris as approved in Page. Now, the facts in this case are confusing. This case was filed in 2010 by Ocwen. Ocwen then filed an amended complaint in 2011 and attached the note, the mortgage, and the assignment of mortgage, which showed that Ocwen didn't have standing when it filed the complaint in 2011. Between the filing of the complaint and the filing of the original note and mortgage, where the note was not endorsed in blank, but it was endorsed to Ocwen. From that time on, 2 different parties and 5 different attorneys dragged this case on and never filed the original complaint. So at the time that the motion for fees was conducted, Ocwen had standing. Ocwen had standing from 2011 on. Nationwide and US Bank Trust, both over the course of several years, filed a notice of appearance, if you want to say, or taking over as plaintiff. And they did it with an assignment of mortgage based on, they say that the mortgage was assigned to them. But the mortgage that the assignment of mortgage that they relied on, at least on this record, was a completely meaningless piece of paper because the note was made out to Ocwen. So US Bank, who appeared in this case based on an assignment of mortgage to them, really didn't prove that that they had any interest in the note. And frankly, the assignment of mortgage was irrelevant. So the only party in this case, or at least the way the pleadings were set up, is that Nationwide and US Bank were prosecuting this case based on the operative pleading, the pleading that was filed in 2011. And all of the confusion that went on as a result of that was created by the various plaintiffs in this case, by mucking up this kind of record. The note was signed, and the assignment of mortgage didn't mean anything. Now, at the time this happened, the defendant, Signorini, didn't know whether these different plaintiffs had certain documents that would allow them to proceed on this case, certain powers of attorney and other things from Ocwen or Nationwide or both. And if they had that, or if they have demonstrated that, this wouldn't have been a frivolous case, but it was a frivolous case, and therefore they lost on summary judgment. Then the question becomes, well, do they owe fees? And the answer is, based on either way you look at this, the answer is yes.
Well, when you say they, let's just be clear. Who are you referring to? Who are you trying to get your fees from here?
US Bank.
Okay.
They are the current plaintiff in this case. They took over this case knowing the case was that the note was signed by Ocwen. When they took over the case, they knew that.
But I think that's what complicates this, is that is the pocket that you all are seeking your fees from, because the Page case makes clear that the no standing, no fees maxim doesn't hold up, but you do have to prove some kind of a contractual relationship upon which the reciprocal provision of 5715 can attach. And that's problematic here, right? For vis-a-vis US Bank. Why is it not?
I would say no. Two things. One is they did an assignment of mortgage. That's how they got into this case.
Okay, let's start with that. An assignment of mortgage, which you've just correctly argued, is itself something of a nullity in terms of passing standing. I think what your suggestion is that it amounts to an assignment of a contract, which I suppose could be true, at least according to that Fourth DCA's recent case, if you construe a mortgage lien as if it were a standalone contract.
You're correct, Judge Lucas. And that's why the Supreme Court's case in Page, if you look at page 691 of the opinion, it says the unilateral fee position in the contracts, plural, at issue. There are contracts at issue, the note and the mortgage. This is a mortgage foreclosure case. They did an assignment of mortgage. It may or may not be enforceable. It's irrelevant. It's got a...
But it's got to be a contract, right?
Sorry?
The mortgage has to be, you have
Correct.
to deem the mortgage a contract. So help me out with, because I think you and I have actually had this.
You and I had this exact conversation before, and you wrote in the Jones case in a footnote, I guess it was dicta, but respectfully.
That's fair characterization. Yeah.
We disagree with that, and I think the Supreme Court disagreed with that. And I think if you read Harris closely, and you say, well, Harris doesn't really mean what it says. It says mortgage contract, mortgage contract, mortgage contract all over the place. And that's what Page adopted. And that's what the Blythe case has taken on. But
help me out. How could, if a mortgage is a standalone contract, in theory, it is freely assignable separate and apart from the note of which it secures, which we know is an impossibility.
Honestly, not my problem. They signed the contract. They signed the contract. You know, we were.
If it's a contract, right? What is
the Harris case said?
What was the independent consideration that was given for the mortgage that is distinct from the consideration that was given in exchange?
There is huge consideration, and that's they get my real property. The note doesn't give them my real property. They get my real property. I'm talking about We've been
The
through this.
consideration that was given, the mortgage is given by the party that owns the property. That is the mortgagor. What consideration does the mortgagor receive for giving that mortgage apart from what they got when they signed the note?
The thing is, the answer is they wouldn't have gotten the loan without the mortgage. And a lot of times, most times, these two things should be considered together. The note and the mortgage should be considered together. But on the other hand, US Bank Trust dragged Signorini into court based on this document and this document only. And let me not forget that they went into the court and they took the note out of the court, which they did not own. If they didn't own the court, why did they take the note out of the court file? And if you read the document, if you read the note, record 517, they write a thing that says on the caption, plaintiff Ocwen, plaintiff's motion to release document. Now comes plaintiff US Bank. And in the pub says, October 12, 2011, plaintiff filed the original note. Which plaintiff? Ocwen. The case was dismissed. Accordingly, plaintiff requests the original note. Which plaintiff? At the end of the day, US Bank, I put it in my brief, I don't know how else to say it. They had no authority to take this note out of the court file if they didn't own the note or have some other documents, which they didn't produce to the court, to say that they owned it. Now, there are two things in this case. Either US Bank owned the note and the mortgage, or they didn't. And we're going forward on the pleadings. US Bank never filed a pleading, didn't file anything in opposition to the summary judgment, filed absolutely no evidence in this case. That's why the summary judgment was entered. But how is it even in this case if that assignment of mortgage doesn't get them in? And they use the assignment of mortgage to take the note out of the court file. So Signorini is just sitting here. Signorini signed a mortgage and a note in 2007. And for the last 15 years, various plaintiffs and various attorneys, and in some case, I'd like to put the thing on the various attorneys who did that, because the various attorneys who transferred notes, the same attorney represented both parties each time they transferred the mortgages. It's a very strange case, particularly when it's clear that the note was signed by Ocwen and only based on Ocwen. But to answer your question, the case is based on the pleading. Signorini can only answer the pleadings. The pleadings in this case are 2011. Ocwen had standing. If US Bank wants to stand in their shoes, good for them. And that's where this case is.
Since you brought up pleadings, Mr. Biasotti, can you address an issue that your opposing counsel has brought up, which is, look, this is not a case where Mr. Signorini says, yes, I'm a party to a contract of some form with somebody, whether you want to call it mortgage, whether you want to call it note, whether it's with Ocwen, whether it's with US Bank, but rather he filed a global without knowledge and therefore denied. And
excuse me. Yeah.
And so do we have a finding from the court below that would say, yes, we do indeed have a contractual relationship between this party and that party? Or aren't you asking us to make a factual finding that there is a contract and a contractual relationship between these people? That's what's troubling me. It seems like if we were to reverse in your favor, we would have to make that initial factual determination.
There are two facts in this case that I don't think can be disputed. Ocwen had standing in this case. They didn't have it at the beginning of the case. They had it throughout the case. Now, the fact that they attempted, or however they brought these various, I should go back. They filed the original complaint in 2010. They filed the amended complaint in 2011. they could never foreclose on the 2011 amended complaint because they demonstrated they didn't have standing in 2010. But from 2011 on, until US Bank took Ocwen's note out of the court file, Ocwen had standing. So you can certainly find, and I think the court could find, that they had standing. Now, it's hard, you got to remember, the trial court granted fees for Signorini.
I know.
And the only reason they changed it is what we think was a misinterpretation of the Hobson case. But in any event, the judge didn't have the benefit of the Page case and the Supreme Court case, and now the Blythe case.
Wouldn't the proper remedy then be to say, look, it looks like you proceeded under a pure legal error here, reverse and remand, but for the purpose of determining whether or not there's a contractual relationship between these parties. And then you have the trial court doing its proper role, which is taking the first pass on this preliminary factual issue as to whether or not there was indeed a contract, and if so, between whom?
We considered filing this under 57105 because, as you know, the property's been foreclosed on.
Mm-hmm.
It was foreclosed on when US Bank's attorneys took the note out of the file, went to the same court, down the block, another judge, and foreclosed on the case. So maybe we should have filed it under 57105. If you want to remand this case, I'd like to see the various 5 attorneys and 3 plaintiffs, what happened in this case. Mr. Signorini is an innocent participant in these machinations done by the various banks in this case. It was a case I cited in the brief that Judge Oldenburn wrote a long time ago, or several years ago, the FOP case, where he says these financial institutions brought this on themselves. US Bank brought this on itself. It either was a party to the mortgage or it stood in the shoes of Ocwen.
Mr. Visadi, just to let you know, you're coming up on your rebuttal time.
Yeah, okay, let me just make one case. There's a big difference between what they say in their answer brief as Signorini denying everything and then just saying, I have no knowledge of any of these things. Therefore, it's denied. For example, the note that he signed was endorsed on the back. He had no knowledge of that. So how could he can't, agree with that. I think without knowledge and therefore denied is different than denied.
Right, he didn't admit that that was his signature, didn't admit anything there was his. Is that correct?
He was without knowledge of what was happening with this case. And therefore he denied it. I think there's a big difference between somebody denying something and somebody saying, look, I don't know. I don't have the facts, therefore I deny it. That's different things.
In general practice, answers will often say, admit as to this fact, that fact, otherwise without knowledge so denied. But that wasn't done here, correct? It was just kind of a general blanket. Don't know what this is, not a part.
Yeah, I think, let me be clear. I don't have the complaint in front of me. But the complaint wasn't very complicated. It was like 9 or 10 or 12 claims. Most of them had to do with things that happened that Signorini would have no knowledge of. He signed these documents in 2007. And anything that happened after that, he didn't know anything about. Anyway, if you don't mind, I'll reserve the rest of my time.
Of course. All right, Mr. Rosenberg.
Do I hit the...
May it please the court, David Rosenberg on behalf of the appellee, US Bank. I'd like to start by just taking a step back and framing the issues and the question before this court. So it's undisputed that under this court's decision in Harris, the moving party, the party moving for fees, Signorini, has the burden to prove that both the movant, Signorini, and the opponent, US Bank, are parties to the mortgage contract. My colleague cites Harris in his initial brief. We cite Harris. It's undisputed. This is the standard. To meet this burden of proof, Signorini alleges in the initial brief that US Bank is the owner assignee of the note. This is important because right now during our argument, my colleague is talking about the assignment of mortgage and whether the mortgage is a separate contract, which we discussed in Jones. I was also in that case. And that's not the argument he makes in the initial brief. His focus is on the note, and he says that US Bank is the owner assignee of the note. And he admits correctly that the mortgage follows the note. He doesn't claim the mortgage is a separate contract. His focus is on the note. In
Actually,
fact,
his brief makes that argument. Fairly read, his brief makes that argument. I don't think you can just breeze past it.
okay, well, Your Honor, I would just refer, he talks about the assignment of mortgage, and this is his language in the briefs. In the initial brief, he characterizes the assignment of mortgage as meaningless. That's page 3 of the initial brief and page 3 of the reply brief. He calls the assignment of mortgage completely worthless. That's his language, page 14 of the initial brief. And the reply brief, page 3, he says the assignment of mortgage is, his language, a useless piece of paper. So his focus is not on the assignment of mortgage in the briefs. And in right now during oral argument as well, my colleague again says that the assignment of mortgage is meaningless and irrelevant. Those were his words in the beginning of his argument. And he talks about the Blythe decision and whether you can just rely on an assignment of mortgage, but that is not the argument he made in his briefs. He calls the assignment of mortgage meaningless, completely worthless, and a useless piece of paper. And that is how he characterized his argument, as focusing on
Yes,
whether
but he also, yeah, I get that, and that's for purposes of the standing argument. But he also does make the argument, and I'm pulling it up now. I mean, you know, they are arguing that the assignment of mortgage gives them a contractual basis for fees. Can you address that argument, please?
Yes, Your Honor. I did not see that argument in the brief. I saw they characterized the assignment of mortgage as worthless and meaningless, but I will address that. We went over.
In this case, both the mortgage and the note contain prevailing parties' attorney's fees. They make it throughout there that, look, both the mortgage and the note have prevailing party fees. We're entitled to it under the assignment of mortgage.
Under this court's, so let me address that.
Yeah, it's right here. In this case, the original mortgage contract by and between Signorini and the original lender included a unilateral attorney's fee clause. U.S. Bank adopted that clause when it obtained an assignment of a mortgage. There's the argument. Can you address it, please?
Yes, Your Honor, I'd be happy to address that. So under this court's decisions, and Judge Lucas, you were a party to its decisions, Hobson and DiGiovanni, this court held that where a party impugns the validity and efficacy of an assignment of mortgage, as my colleague did by describing it as meaningless, worthless, and useless piece of paper, where you impugn the validity and efficacy of that assignment of mortgage, you cannot later use that same document to obtain fees. Those are two decisions from this court. Obviously, Judge Lucas, you're familiar with those as you were on the panel for both of those decisions. We also did address this in Jones. Judge Lucas and Judge Smith, you were on the panel as well. I was here with my colleague, and we argued whether an assignment of mortgage is a separate standalone contract. And Judge Lucas, you asked the same questions there that you ask now, which is, what's a contract? What comprises a contract? Offer, acceptance, consideration. And you asked my colleague, Mr. Biasotti, what was the consideration for the mortgage? And he answered in Jones, the promissory note, which is what Your Honor was trying to get to here as well. And you can't look at these two documents separately. He admitted below and admits on appeal, and he does admit this, that the mortgage follows the note. He doesn't describe them. He says the mortgage contract, and you're correct, Your Honor, he says note and mortgage, but he does not say mortgage alone. He talks about the assignment of mortgage, sure, and he does describe it as meaningless, completely worthless, as I said, but he talks about it together with the note. He acknowledges that it's all one big contract, and that is what his initial brief says. At no point does he say that he's seeking fees only under the mortgage. Now, in the record, in the trial court, he did make that argument. He did argue that he was seeking fees only under the mortgage, but he does not make that argument on appeal. He talks about the assignment of mortgage, and he says that this is part of the evidence that was presented to the trial court establishing that US Bank was a party to the contract, but he identifies that contract as both the note and the mortgage. At no point does he disregard the note. In fact, he says that what he's trying to do is he's trying to prove that we are a party to note, that he says the undisputed evidence before the trial court is that US Bank was a party to the note. And that is his argument. So a couple things there, right? Under Hobson and DiGiovanni, you cannot use an assignment of mortgage to collect fees from the other party after you have impugned the validity and efficacy of that assignment of mortgage. He did that below. The reason that he prevailed in the trial court is he argued that US Bank did not acquire any rights in the note because the assignment of mortgage did not convey the note as well. It just assigned the mortgage. That was his argument to the trial court, and he prevailed on that. And under this court's rulings in Hobson and DiGiovanni, this court says that when that happens, when you prevail based on arguing against impugning the validity of a certain document, you cannot turn around and say that we're going to use the same document to collect fees from the other side. Now, this court didn't identify a particular doctrine in Hobson and DiGiovanni that I could see explaining the rationale behind this, but my understanding is this is rooted in principles of judicial equitable estoppel, that you can't make that one argument and say that this document is meaningless and prevail based on that argument. And then after you've prevailed based on the argument, turn around and say, well, actually, this very document shows that we can collect fees from them.
But Mr. Rosenberg, doesn't that doctrine apply to another case, not the case in and of itself? Isn't that what was clarified?
The doctrines of judicial and equitable estoppel.
Yeah, I mean, it's in another case, right? I mean, I think that's what the case talks about, is that the doctrine's going to apply to another case, not to prevent you from making the argument in the same case.
There is a case from this court, let me see if I can locate quickly, where it does clarify that another proceeding can qualify as a separate proceeding, that there are two parts in a foreclosure case, right? There's the foreclosure portion where you rule on the complaint, and then there's the attorney's fee portion, which is a separate portion of the same case, results in a separate final order, obviously, as for on appeal, that separate final order.
But
And
that's
there is
not,
case,
we're not, okay, go ahead.
right? So what Signori did is he prevailed in the foreclosure portion of the case. He obtained a final order, summary judgment in his favor, saying that we didn't have standing, and he won that portion of the case and obtained that final order by arguing that the assignment of mortgage was ineffective to convey any rights to US Bank. So once the foreclosure portion of the case was over, he moved to the attorney's fees portion, and that's where now he's saying, and this is essentially a separate proceeding, right? This is based on his motion for attorney's fees and our response. It's a separate proceeding within the same case. And he says that that now this assignment of mortgage is going to convey those rights to US Bank, which is the exact opposite of what you argued in the foreclosure case. And that's what this court's decisions in Hobson and DiGiovanni addressed. And whether you're going to use those doctrines or use just the plain language of those decisions, which talks about imputing the validity and efficacy of the document, the conclusion is the same. He impugned the validity and efficacy of the assignment of mortgage. That's exactly what happened in DiGiovanni. That's exactly what happened in Hobson. And that's exactly what led this court in those cases to say that he could not then turn around and say that these documents prove that they are party to the mortgage contract. If that answers your Honor's question. So that's the response to the assignment of mortgage. And again, I do still stand by the argument that he characterized these assignments of mortgage. Not only did he dispute their efficacy and impugn their efficacy below, but he's doing it on appeal. And whether under a fair reading or not of the initial brief, you do have language in the initial brief as well, like he did in the appeal, where he's saying again that these assignments of mortgage are meaningless, completely worthless, useless piece of paper.
That is
Those are his words. So just like he did below, he's doing it on appeal as well. Now, I want to touch on a couple other things. He does not request and did not request an initial brief a remand for a new hearing. So I would submit that possible resolution of this appeal is not properly before this court, because that is not relief that was requested by my colleague in his initial brief.
You have to specify the kind of remand that you want when when you bring an appeal?
He
Or-
did.
Or risk waiving it?
I would say that you have to say you want remands, period, that you want a particular issue to be adjudicated. If he had, I would have cited, for instance, this court's decision in Tracy, where this court talked about the limited circumstances under which a remand is appropriate. He didn't brief it. I didn't brief Tracy. To the extent this court recalls the language in Tracy, it says that the general, my recollection is the general directive is no remand for a new hearing once you've had your shot. And he had two
But
hearings here.
The ultimate rule in it is that it's a function of the appellate panel's discretion.
Correct, Your Honor. Yes. So, but to talk about the discretion, to argue about the discretion, we should be afforded the opportunity to argue that the discretion should be exercised in favor of no remand. And
At a minimum, at the briefing level and not an oral argument, I think is what you're hinting at.
correct, Your Honor. And he had, I'll note that there are multiple hearings in this case. There's a February 2019 hearing. There was a December 2019 hearing. The issue of attorney's fees went on for some time. So my colleague certainly had ample opportunity to present evidence or conduct discovery or what have you, and make his case that US Bank was a party to the mortgage contract, and he didn't. We deal with this all the time, obviously.
Can you do me a favor? Let's try to steer clear of the word "the mortgage contract" and just like when you're talking about the note, talk about the note. When you're talking about the mortgage, talk about the mortgage. Just so that we're keeping clear, because that seems to get confused sometimes.
Of course, Your Honor. So he had multiple opportunities to prove that US Bank was the owner or assignee of the note, and he didn't. He could have presented evidence. He could have sent, say, a request for admissions or interrogatories, or just conducted discovery or subpoenaed a witness to appear at either of the two hearings in this case, or scheduled another evidentiary hearing. He had years to make his case, and he didn't. And under this court's ruling in Harris, again, that burden is on the movement. Now, we face this problem all the time in foreclosure cases, right? A lot of times plaintiffs have trouble proving their standing, but we go through the motions of collecting our evidence and making our case and presenting that case to the trial court for a factual determination. He never did here. Judge Lucas, like you said, some of his arguments would require this court to make a factual determination for the first time on appeal. For instance, the claim that Signorini is a party that actually signed the note or mortgage. We alleged in the complaint that he did. He categorically denied it. Judge Stargell, as you noticed as well, he could have done a partial admission. We entered into a mortgage contract, a note and mortgage with the parties, but we aren't sure if this is the exact document or not. He could have certainly done a partial admission. He didn't. He did a categorical denial that remained valid and of record throughout the entire case. And at neither of the two hearings did he present any evidence that he actually signed the note or mortgage. So at a minimum, this discrepancy in the pleadings, we allege he did, he alleged he didn't, create an issue of facts that would make an incumbent upon my colleague to present evidence. Because again, under Harris, that the moving party has the burden to present this evidence. And I also note that in the initial brief, my colleague does make this an evidentiary issue. He says that, these are his words, page 15 of the initial brief, the sole issue, and his words, is if the evidence, his words, proved that US Bank was the owner or assignee of the note. So he's presenting this court with an evidentiary question. And under this court's precedent, this court, the trial court's factual findings are reviewed for substantial evidence, and this court does not reweigh that evidence. It does not substitute its judgment for that of the trial courts. So if there is sufficient evidence or a lack thereof in the trial court that would support the trial court's ruling, this court affirms, and that's what it should do here. There's no evidence that Signorini signed the note or mortgage. He denied it, and he never presented evidence on that. That alone is dispositive. Second, there is no evidence presented to the trial court, sufficient evidence that US Bank was the owner or assignee of the note. And he makes several different theories for why US Bank is allegedly a party to the note. I can get into those if you want. They're complicated, convoluted, complex theories for why US Bank is a party to the note. We argued in our answer brief that he didn't preserve any of those arguments below. I'll note that in his reply brief, my colleague did not disagree. So we raised a lack of preservation argument. We said this court should not consider any of his arguments because he did not make them below. regarding whether US Bank was an owner or signee of the note. The reply brief did not disagree. He should not be able to change his position now or insert a new argument against preservation at oral argument. So that's what we have here. We have the failure to meet that burden under Harris, failure to prove that he was a party to the note or mortgage, and the failure to prove that US Bank was a party to the note or mortgage. Now, I'll note in addition to waiving those, my colleague actually, or rather Signorini's trial counsel, represented to the trial court that Ocwen had the note. That's on page 783 of the record. So not only did he not present evidence that US Bank was the owner or signee of the notes, but he affirmatively argued to the trial court that the note remained with Ocwen. The trial court asked approximately, under these factual circumstances, the note is still with Ocwen? Signorini's trial counsel, yeah. So those were the arguments made to the trial court. And those are the arguments before it, and that was the evidence before it. And this court's job on appeal is not to reweigh those evidence, not to put itself in the trial court's position, but just to say, is there insufficient evidence or sufficient evidence, what have you, supporting the trial court's ruling? And there is. And again, Judge Lucas, like you noted, he never even asked for a factual determination about whether Signorini was a party to note or mortgage. So this court is, and that is one of the elements that he's required to prove under Harris. So if this court would issue a decision in his favor, it would have to address that element. And by addressing the element, it would have to be making a factual determination for the first time on appeal. This court has no other questions. There's one other thing I want to quickly address. I want to address Page. And we explained this in our answer brief. I just want to reiterate, as this court is aware, Page approved this court's decision in Harris. And all of our arguments here, they flow directly from Harris, which Page approved and affirmed. And by affirming Harris, Page confirmed that the movement has the burden. And in fact, Page went through this exact analysis on page 959 of the opinion. They said that the record shows that the contract was entered into by Page. We don't have that here. They said that the bank on some day uncertain succeeded to the rights of the originating lender. And they said that the evidence, their words, established the contractual relationship between the parties. So they're looking at record evidence. And just the same way that banks have to prove their standing by evidence, not with speculations, not with arguments of counsel, but with evidence, it's incumbent upon the party moving for fees under this court's test in Harris to satisfy that same burden, to meet that same evidentiary standard, to present evidence or refer to evidence proving that US Bank is a party to the note and mortgage. And without, I don't want to be construed as giving advice to opposing counsels, but it could be pretty easily done, assuming that they are a party. You send a request for admissions. Are you a party or not? You send interrogatories. Are you a party or not? You subpoena the person who's a trial witness. Put them on the stand, ask them. They could have presented evidence here, but they didn't. And the trial court's decision is supported by the arguments and the lack of evidence before it. This court has no further questions on that. This court should affirm. Thank you for your time.
Thank you, Mr. Rosenberg. Mr. Biasotti.
Sir, yeah, I have
Go ahead.
US Bank filed one document in this case, an assignment of mortgage. It's the only thing they filed. We didn't need to do a request for admissions. Is that really your assignment of mortgage? It's the only thing they filed. It's why they're here. It's why they're in this case. So the whole concept, I mean, Mr. Rosenberg brought up, and maybe it wasn't clear. The note was endorsed to Ocwen, and it was in the court file from September 2011. It was always there. The mortgage, the assignment of mortgage from the original mortgage to Ocwen is in the record. From that day on, no evidence was put in this case. We have a very simple case in this case, given Page. And Judge Lucas, I know you hate mortgage contract, But if you read Harris, it says mortgage contract probably 20 times. And that's what Page adopted. And that's what Blythe said. If you're a party to the mortgage and the mortgage has a fee, you're entitled to fees under 571057. Now, Page comes after all the cases that Mr. Rosenberg discussed. It's after Jones, it's after Hobson, it's after all those things. Now, I think we can, I don't want to speak for the court. We assert that Hobson did not stand for no standing, no fees, which is what the trial court decided the order that's on appeal. That's what she decided, and that's wrong. However, on appeals, like this appeal, you're governed by the current case law, Page. And Mr. Rosenberg and I had this discussion when Page came out, and he amended his brief to account for Page. Now, Signorini did not need to present any evidence that he was a party, that US Bank was a party to the mortgage contract by the assignment of mortgage. And if they did not own the note, why did they steal it from the court file? You don't like steal. Explain it to me how else you could say that. If US Bank did not have the right to that note, why did they take it and foreclose on it? And, you know, there was some discussion, and I attached as an amendment, as an addendum to the initial brief, the various cases that after they got the note, they foreclosed on it. Talk about estoppel. You're talking to two judges in the same court, and I'm not a party to it. I am a party to it. That's the estoppel issue. Anyway, if this court feels that the footnote in Jones that a mortgage is not a contract is correct, I think that's contrary to Page, Harris, and Blythe. And you should deal with that however you want, in opinion.
All right.
Thank you.
Thank you both.
Yeah.
Have a great rest of the day. And at this point, that is the last case on our docket. So we are now adjourned.
Last case for the
Thank you all.
month.